Hello, everyone. My name is Rachel with Aging Advantage, and Aging Advantage is a nonprofit that assists disabled adults and seniors in the St. Louis area. And today we have Dean presenting on estate planning and how it can help caregivers. So I'll give it away to Dean.
Thank you, Rachel. I share my screen. So, as Rachel just said, my name is Dean Garros. I am an attorney and I specialize in estate planning and probate law. Today's presentation is just going to be kind of a basic, what is estate planning? What are the documents? How do they work? Why are they important? Why you should get them set up now, that type of thing. And I'll kind of offer some tips along the way. But first, let me just kind of give you some information about the law firm that I'm with. The firm is called True Estate Planning, and we are located in Old Town Florissant in North County, right off of St. Catherine Street. And this firm was created about a year and a half ago. And there's two attorneys at the firm, myself and then Kelly Spann. And this firm was really so Kelly, she mainly practices in trademark and franchise law, and she was doing some estate planning on the side, and she was referring out the majority of people that needed estate planning services. But what she found was that when she was referring them out, either people were getting priced out, it was too expensive, the process got to be, overly complicated, or there were attorneys that were recommending certain documents and plans that maybe the client didn't necessarily need. So Kelly kind of saw, a void in the marketplace for offering estate planning services to the average person, while keeping it somewhat simple and affordable. Um, so that's kind of the whole motto behind the firm. We do want to offer these services, for the average person. Now, when we talk about estate planning, what are we talking about? There's usually, I like to refer to it as like a pancake. There's really two sides to estate planning generally. And the first side is the distribution or planning for the distribution of your assets at your passing. And we're really looking to shoot for two goals when we plan for the distribution of your stuff. So we're looking to avoid probate. And all probate is a court process, where a judge will retitle assets, make sure creditors get paid, things like that. But the reason why probate is kind of looked at as a boogeyman is because it's expensive, it's time consuming, and for the average person, they cannot wait a year before they can, sell a piece of property or something like that, or before they get access to assets. And another big thing is you're going to lose, a small chunk of the estate, just to filing fees, attorney fees, things of that nature. So the goal is if we can avoid that process, that's what we're going to shoot for. And the other goal is we want to make it as easy as possible for your loved ones or whoever your beneficiaries are to get access to your assets so that they can do what they want with them after you're gone. And I always like to say if we can make it easy for them to get access to everything quickly, it kind of allows them, proper time to mourn, and they don't get, a lot of personal effects and, personal property tied into the grieving process and stuff like that. And the other side of estate planning is planning for the event something happens to you while you're alive, and you can't make decisions for yourself. So if you're in a coma, you develop Alzheimer's, you have a stroke, and you cannot sign your name, talk to your doctor, do kind of the simple things in life. We want to make sure that we have powers of attorney set up. And kind of the main goal that we're shooting for when planning for your incapacitation and making powers of attorney is we want to avoid your loved ones from having to get guardianship or conservatorship over you. It's kind of the same situation with having to go through probate to distribute your assets. It's, more time consuming, it's very expensive. It's also embarrassing too because your family might have to present evidence of why you cannot make certain decisions for yourself, things of that nature. Um, so, turning to planning for the distribution of your stuff at your passing, we have many tools that estate planners use to accomplish avoiding probate and getting the assets quickly to your loved ones. And one of the quickest ways, and honestly, best ways to do it and keep it simple, is the use of beneficiary designations. They're also commonly referred to as POD or TOD designations. And all they stand for is payable on death or transfer on death. Payable on death is for stuff like bank accounts. Transfer on death is for vehicles, stocks, things of that nature. Um, One of the benefits of having beneficiaries on, life insurance, your bank, your retirement accounts, is that just by virtue of having someone as a beneficiary, it automatically avoids probate. So if you have a will, which I'll get into in a second, it will supersede that. If you have a trust, it will supersede that, and it will go directly to the named person as the beneficiary. Um, so it's also important to keep those updated, especially if you have someone listed that has passed, or maybe you've gotten remarried and you have your old spouse down, something like that. It's a good thing to double check those maybe every couple of years to make sure they're updated. Now, assets like real estate, we can handle those through what's called a beneficiary deed, which is for the most part pretty self-explanatory. It transfers the property at the person's passing to the named beneficiary. It avoids probate, and it also gives that beneficiary stepped up in basis for tax purposes. Um, so typically, when someone buys a house, whatever the value of the property that day, if they hold on to it for 20 years and then they sell it, they're going to have to pay the capital gains tax, or they might have to, for the increase in value during those 20 years. But whoever inherits the property through a beneficiary deed, whatever the value of the property is the day they inherit, is their new basis. And if they turn around and sell it a month later, most likely they will not be on the hook for any capital gains taxes. Um, so the use of a beneficiary deed, I've heard it explained as kind of like the difference between a tailored, suit or off the rack. This is more off the rack. It gets the property to your named beneficiaries, but it might not be the best way to do it, especially if you have more than one beneficiary for the property, which I'll kind of touch on that in a little bit when we talk about revocable trusts. But some of the tips that I have for beneficiary designations, especially bank accounts, um, try to stay away from picking one child as the sole beneficiary. I've had this situation come up numerous times with clients where, maybe they have three, four, five kids and they just pick one as the beneficiary, and they're kind of, picking that person to split the money to their siblings once that person is gone. It's not a good idea because there's no legal obligation for that child to split the bank account or something like that with their siblings. Um, so it's generally not a good idea to do that. If they do end up gifting portions to their siblings, they might also have to fill out gift tax returns and stuff like that. So if you have a simple asset like a bank account and you want it to go to multiple people, multiple children, just put all of them down as the beneficiaries. It definitely cuts out, potential headbutting in the future. And another common thing that I see is people putting their child as a joint owner on a bank account or something like that, with the goal in mind of them being able to have access to it, to write checks, or to pay bills or something like that. This is generally thought of as not, a good idea, because if that child, gets into a car accident, they get sued, they can, the person suing them, they can come after your bank account because your child is, on it as a joint owner. Um, and lawyers can get pretty creative when going after assets to satisfy damages. So generally, you want to stay away from that. And if you want to add them, to have access to the accounts, to sign checks or pay bills or something like that, we can either handle that through a power of attorney, which I'll go over in a little bit, or you can add them to have signature access on the account. Um, but generally, it's a good idea to avoid naming a child as a joint owner. Another common estate planning tool to distribute your assets at your passing is the use of a will. So this is the popular one, the common one that most people think when they think of estate planning. They think of a last will and testament, and most people think that by having a will, you keep your assets out of probate. But it's exactly the opposite. If you have a will, it's literally instructions to the probate court, to what you want to have happen with your stuff, who you're picking to administer the estate and stuff like that. Um, Typically, for the average person that doesn't have too many assets and they only have a couple beneficiaries, um, it's kind of a combination of the use of beneficiary designations with the will as a backup. So in that scenario, if you have beneficiaries for everything, the will would just be there as kind of a safety net. Maybe you get a new asset in the future and you get hit by the proverbial bus and you do not set up beneficiaries on the account. At least in that scenario, your will would catch it, and it would distribute it to the people that you want. Um, if you also have a will, it can kind of cut out a lot of the noise if an asset has to go through probate. So it can cut out some extra fees and some extra requirements from the court. But it's always good to have just in case, because if you don't have a will, the government has a plan to distribute your assets. So, that might not be exactly how you want it to be. If you have stepchildren, they would not be included. If you have children from a previous marriage and you want to make sure that they're included and stuff like that, you want to make sure that they're written out in the will, just in case. The other common estate planning tool to get your stuff to your loved ones is the use of a revocable trust. Um, so I like to explain revocable trusts. Revocable just means you can make changes to it. And I like to explain trusts are just, they work like a contract. So because they work like a contract, the administration of it is entirely private. So it can, the document never has to get filed in court like a will does. It does not have to have a judge oversee the distribution or the administration of it. It basically allows the person who makes the trust to put property into it while they're alive. They can take property out. They can add people in to get that property once that person passes. But once the maker of the trust passes away, that document becomes irrevocable, which means no one can make changes to it. And the person that you select to kind of take over is just following your directions and dividing up assets for loved ones, maybe holding it for minor beneficiaries, stuff like that. So, um, like I said before, the planning for the distribution of your assets is kind of a combination of all of these. I don't, recommend trusts for everyone. In my mind, trusts should really only be there for, specific scenarios where they're absolutely needed. One of those being if you have minor beneficiaries. So minors, they can inherit property, they just can't own it. So if you have minor beneficiaries, you can allow the trust to hold those assets for their benefit. And then once they reach, a certain age that you select, then they would be able to get access to their inheritance and to kind of do what they want with the funds. But another big thing is kind of saving the beneficiaries from themselves. So maybe if you have a beneficiary who's not good with money, maybe they have a gambling problems, spending problems, stuff like that. You can formulate a trust to hold the funds for their benefit, and maybe it's only used for big items like health, education, maintenance, support, things of that nature. Um, Another good strategy to use a trust is if you have special needs beneficiaries, because if you have a special needs beneficiary and they're on public benefits, you don't want them to get an inheritance and then that kicks them off whatever public benefits they're on. So if you have a trust and it's set up to hold the assets, it's typically referred to as a special needs trust. You can structure that document to hold the inheritance for that special needs person. And it kind of acts as a supplement to their public benefits. So it allows them to stay on, and it also allows them to get an inheritance. Another big strategy for the use of trusts is just for real estate. So maybe the average married couple has, a couple bank accounts, they have life insurance, they have retirement accounts, a couple vehicles, and their house. Maybe we take care of everything through those beneficiary designations except the real estate. So if the real estate is going to go to more than generally two people, or if multiple beneficiaries live out of state or out of the area or something like that, maybe we just want to have a trust just to hold the real estate. Because if we use the beneficiary deed route, say you have four beneficiaries for the piece of property, all four of them are going to have to sign off on even to sell it, who the realtor is, counter offers. They're going to have to be on the same page throughout the whole process. But if we use the use of the trust, or the use of the trust is good, to basically allow one person to deal with the sale, as long as they sell it for fair market value, then they can just distribute the proceeds to the other beneficiaries. But it kind of just makes the process a little bit more, clean. I know everyone's family is perfect, and the chance of headbutting might not be great. But whenever people pass away, grief, does a lot of things, differently to people. Some people act a lot differently, and maybe they, attach themselves onto a piece of property and they don't want to sell it or something like that. Bottom line, it just creates a lot of problems, for the people who do want to sell it, or the ones that maybe want to rent it out, get an income stream, that type of thing. Um, so the other side of estate planning, like I said, is planning for the event something happens to you while you're alive. You're in a coma, you develop Alzheimer's, you have a stroke, and you can't make those everyday decisions for yourself. You're going to want to make sure that you get powers of attorney set up now while you have capacity, so that you have the freedom of selecting who would be able to step in at that point, to act on your behalf. So there's two different types of powers of attorney. There's a healthcare, which allows the person that you select to access medical records, talk to your doctor, fill prescriptions, and in the event you're ever incapacitated and terminal, it would allow them to, make major healthcare decisions on your behalf, aka they can remove you from life support, let you go peacefully, that type of thing. Um, and the other power of attorney is a general power of attorney. It's basically everything else outside of healthcare, but typically it revolves around financials, signing your name on your behalf, um, dealing with financial institutions, that type of stuff. Um, Tips for powers of attorney. Generally, I usually tell my clients to try to avoid having multiple people act at once, especially just two, because if they're not on the same page, it could present some problems for acting. So if one of them is refinancing your house, but the other one's getting ready to sell it, it could present some problems. So generally, it's good to just have one person named and then have a backup and then maybe another backup to that person. Doesn't mean they can't talk, to the other named people or to their siblings or something like that. It's just, ultimately going to come down to just one person making, the decision. As long as it's in the maker of the power of attorney's best interest, um, then they would be allowed to act on their behalf. Um, oh, sorry. Another tip is taking your medical or healthcare power of attorney, or if you have an advanced healthcare directive or a living will, which those are basically your wishes in the event you're terminal and you're incapacitated. Do you want life support to be removed, stuff like that? And those are used in conjunction with healthcare powers of attorney. But if you have any of those currently, I would take those to your doctor so that they can scan them in to your medical records so that if there's an emergency, they'll know who to contact and stuff like that. And I would also give copies to your agents just so that they have a copy. Again, in an emergency, they can, take it directly to the hospital or wherever you're at. They don't have to fish around for documents at your house um, or stuff like that. But um, so generally, this is when I open it up to questions because, as much as I like talking at you, I really like to talk with you. Um, so if there's any questions, I would be more than happy um, to answer them.
Hello. I don't have a question, but I just wanted to say I thought it was interesting that you said to only um not only have one child as a beneficiary because I always thought it was the opposite. So I thought that was interesting. And how your recommendation for like it revolves around our type of care whenever disabled adults get an inheritance. Like I thought that was smart, like not naming them so they don't lose their benefits.
Yeah, because people work or it's typically a long process to get approved for those benefits. So you do not want something as simple as an inheritance, to mess with that because if they get an inheritance, they get kicked off the benefits. There's no guarantee that they'd be able to get back on those benefits, at a later point. Um,
We have a question from a viewer. They said, are there other reasons to do a POA? Like, doesn't Missouri have a next of kin situation?
they really don't. So even with spouses, if you're at the hospital or something like that, technically speaking, if you do not have a medical power of attorney, your spouse cannot make these decisions on your behalf. Sometimes doctors will, but especially when there's multiple people that are, telling the doctor to do something, that's where it can present a problem. So it's recommended that you get powers of attorney set up now. Best case scenario, they're never used, but at least if that situation does come up, you do have them, and they're ready to go. Um, so yeah, I mean, I would just say kind of as a general matter, I would think about getting them even if you're young, and the possibility of dementia or a stroke is not, way off in the future or something like that.
Okay, that makes sense. I like the meme on there.
I'm sorry, I keep clicking my thing. Yeah, I thought that was clever. Um, And I
Yeah.
think there's another question here. Would people be apprehensive about creating? Oh, why would people? In my experience, the biggest thing is the cost. Um, most people do not have. So I used to work at a couple bigger firms offering these services to people, and the average person or married couple does not have, $3,000 to $5,000 to spend, on these documents to get them implemented. So that was, one of the goals with creating our firm. So, for example, a basic, trust package, which would include a trust, a will, powers of attorney, and then we would do a deed to cover the house. That would just be a flat fee of 1,500. So our prices are obviously a lot cheaper for people who need a little bit more advanced planning. That's something that we would talk about, obviously, but people who have over $13 million, that's when you start to hit the estate tax limit federally. So at that point is usually when I tell people you're outside the scope of what I normally do, and I would refer them out to someone who's a little bit more um, suited to handle their situation. But my biggest experience, it's definitely cost. Um, and honestly, procrastination. This is not a sexy topic. It's not really something that people like to think about. So people usually put it off, and it takes, a major life event like a death, or maybe they went through probate for their parents or something like that, to get them to implement these documents. Um, but I always tell people once you kind of come in, you get this stuff set up. It's kind of like ripping a band-aid off. You'll be able to focus on other important things, and you'll get that peace of mind. So yes, another question: couldn't people get information online to be cost effective, or are those not helpful slash legally binding? So services like LegalZoom or something like that, you can use them. I wouldn't necessarily recommend it because if the documents are not executed properly, that all of that work was for nothing. Um, and also, there might be some small, little strategies that attorneys can recommend, to get your assets quicker, maybe to your loved ones or something like that. But generally, I would stay away, from those do-it-yourself type of services, just because the potential to mess something up is great. Um, and I always joke that if you have an attorney set the stuff up for you, if there's ever a problem, there's always recourse and you can sue the attorney. If you make a mistake doing it yourself, there's really no recourse for your loved ones, stuff like that. So um, that's generally what I would recommend.
My
And
question
actually,
is, oh,
yeah, go
sorry.
ahead, go ahead. Oh,
I was,
go ahead.
I'm sorry. You go ahead.
While I think of it, there is another, common question that I get is how often, if you do have an estate plan, how often should you get it updated or have it looked at or something like that? Obviously, if there's been a change in law, or a major life event like a death, a birth, something like that, divorce, you're going to want to call your estate planning attorney to see if there's any holes that need to be plugged. But for the most part, generally, about every 3 to 5 years, maybe take it to an estate planning attorney, have them review it, um, to see if any changes need to be made.
We have a
Sorry,
question.
go.
We have a question from Facebook. Do you all have payment plans for this type of um, assistance?
Correct. Yes, we do. We'll definitely work with people. We take payment plans, no problem. Yeah. We also offer, um, because estate planning is not a once size fits all, approach to people. Everyone's different. So we also offer, a la carte pricing. So maybe you only need a couple documents, you don't need the whole package or something like that. Um, we would offer just separate document pricing as well.
Okay. This is such great information. We really appreciate you coming on today.
Yeah, thank you. Thank you for having me.
Yeah. Such a great opportunity for us to have you.
Yeah, and if anyone has a question, for myself, they want to reach out, I can put my email in the chat box. I don't know if you want to give that. You can give it out to the Facebook group. That's okay with
Yeah.
me. And then I will put our office number.
And then we did have another question. Are you aware of any other helpful tips you could think of?
Um, I mean, not that I can think of off the top of my head, but just if you do not have these documents set up, I would strongly consider, at the very least, getting a power of attorney in place. Because if you don't have a will, if you don't have any beneficiaries set up, like I said earlier, there is a plan to get your assets to your family. It might not be the best way, but at the very least, if something happens to you, you're in a car accident, something like that, make sure you have the powers of attorney set up, now.
Okay, that's good to know. Especially when you're not expecting those life events, you never know like what can happen.
Correct. Yeah. I mean, we all don't have the crystal ball, um, and I'm in the business of planning for things that could happen. So you might not see the benefit now, but at a later date, if you actually have to use or your family has to use those documents, I mean, they will almost be priceless at that point.
Alrighty, well, I think that's all for today. We just want to thank you again for coming on and thank you for your time.
Yeah, no problem. Thank you for inviting me. And if anyone has any specific questions, feel free to give the office a call or shoot me an email.
Perfect. Thank you.